I'm George Curtis. Welcome to It's Your Law. Each week it's my privilege to bring guests that teach all of us a little bit about how the law is working, how it gets put together, how it's supposed to work, and how it sometimes works, and what we can do to fix it if we don't like the way it's not working. This week my guest is attorney Mark Pennow. He's an attorney in Green Bay with the Menn Law Office, a longtime trial lawyer. I've known him for many years. He's defended a lot of insurance companies, and so I've tangled with him in that respect because I'm on the other side of the fence. But he's also represented injured people, and he's become one of the most impressive and successful mediators in the state of Wisconsin. As a matter of fact, that's why in early September of 2014, he's in my office. He's got a mediation where he's going to be working in about a half hour trying to mediate a case where I represent somebody who was injured in an auto accident, and the mediator for the the attorney for the insurance company and I have agreed that we want Mark Pennow to do the mediation. So who's better to explain to you what's happening in our personal injury litigation practice and how important mediation has become. Welcome, Mark Pennow.
George, good to see you again.
Well, it was just last week that you were here on a mediation and successfully mediated a case. I think we have another one scheduled in about a week and a half, so this will be the third one in a month. How many of these do you do in a year?
I'm averaging about one a day now, George. I see about 180 to 190 cases in mediation every year.
Well, now that's been a change over the past dozen years, hasn't it?
That's for sure. As you mentioned, when I started practicing law on June 3rd, 1980 at 8:15 in the morning, I began working with insurance companies. And then into the 90s, at the request of some friends of friends, I began representing injured people as well. And so that, I guess, led to a sense amongst the trial lawyers that I was sort of a centrist, sort of a guy who found himself in the middle often on a lot of these issues, and that led just naturally to being asked to do mediations.
Well, you can see both sides because of having been in the trenches all these many years, and that's awfully important because one of the roles of a mediator is to listen.
Exactly right. That's a big part of the job, to make sure that people feel that their case is fully presented to the other side. My big job is to make sure that both sides see both sides, not in an effort to convince them one side's right and the other side's wrong, but just simply to appreciate that both sides have a point to make if, in fact, the case goes to trial.
The trial practice itself has changed a lot in the last dozen years. Can you give a kind of your impression of those changes?
Oh, very much so, George. I'm privileged to be the chairman of the board of directors of the litigation section of the state bar this year. And I've been on that board for about 5 years. We commissioned a study about 3 years ago to try to determine whether there was truth to what we were perceiving, that most cases settle. Well, our study revealed that during the year we examined, there were 6,500 personal injury cases pending in the state of Wisconsin, 6,500. Of those cases, during that same one-year period, there were 305 trials to verdict of those cases. So we discovered that 96% of the cases don't wind up going to court. They wind up settling beforehand, generally in mediations.
Your experience as a trial lawyer and mine as a trial lawyer probably is pretty consistent with that. I remember 20 years ago, 30 years ago, 40 years ago, 50 years ago, I was having 15 to 20, sometimes more than 20 jury trials a year. So far this year, in 2014, I've had 3. At the end of the year, I will have had maybe 6. That's a diminished number of trials, yet I have more files than I've ever had. What's happened?
Well, it's remarkable. I think this mediation process has really begun to stir the pot at an earlier point in these cases. Sometimes, in the old days, you'll remember that we wound up trying cases simply because the focus on settlement didn't take place until it was too late to do anything about it. And so we wound up trying cases often simply because we didn't consider the topic of resolving them soon enough. But now this mediation process, as ordered by the court, requires us to pay attention to resolving the case at an earlier point in the proceedings. It helps everybody. It helps the litigants, it certainly eases the burden on the courts, and it frees the lawyers up to go on to work on the next case they have to confront. That's how you can have more files and fewer trials at the same time.
There are some factors that seem to make a trial, especially in a small case, incredibly expensive. Can you discuss that a little bit, Mark?
Absolutely. Well, there's three factors that enter into it financially in terms of the plaintiff's bottom line, if you will, about the money the plaintiff, the injured person, ultimately gets. The first is that attorney's fees go up. As a case goes through trial, often the lawyer's agreement with the plaintiff requires that person to charge more. And that's understandable because there's a lot of work in trying a case, George, as you and I both know. The second factor is that the expenses that are incurred in trying a case are significant. Even a minor case can involve expenses in the range of $8,000 to $10,000, maybe more than that, as much as $15,000 for a relatively modest case. The principal reason is that we take the valuable time of doctors to prove these cases, and the doctors need to be compensated for that time, thousands of dollars. We certainly don't suggest for a moment that they're not worth it because they have important work to do otherwise that we interrupt. But still, the expense of a trial is a reason why settlement makes sense. And also, there are subrogation interests. Often, for example, your health carrier pays $10,000 worth of your medical bills as a plaintiff. We know that if we can settle the case before it goes to trial, that health insurer will often accept less than full reimbursement simply to be able to close the matter, avoid the further trouble, avoid the legal fees that they will incur in representing their interest at trial, and so they're willing to take a compromise as well. So all around, we keep the costs down, and the bottom line for the plaintiff turns out to be better often than if we would have tried the case.
Well said. Let's take our first break, and when we come back, I'm going to have you tell the folks how mediation works.
Very good.
We'll be right back. Welcome back to It's Your Law. I'm George Curtis and attorney Mark Pennow, who is here for a very legitimate reason anyway. He's going to be our mediator in a mediation that starts in about an hour. He's given us some time to explain mediation and how it fits in the civil justice system. He explained that one of the reasons why mediation is so popular now is simply cost. We bump into a problem daily where I don't think my client is getting enough money at, let's say, $25,000 or $28,000, but we figure out that if we went to a jury and got $40,000, the client would get less. And unfortunately, with those kinds of choices, or fortunately, the client in most cases says, well, I'd like to go to court, but I don't think I can afford to go to court under those kinds of numbers. So it does work most of the time. What percentage of the time does it work, Mark?
Well, we know from our earlier study that we only try about 4% of the personal injury cases in the state. And that's been my track record as well, I think. Generally, I settle about 19 out of 20 cases that come before me.
Well, most people say, well, mediation, I've heard of it. Exactly what is it and how does it work? That's a better question.
Well, the first thing we should understand is that mediation is sort of like a timeout in a lawsuit. Every other day when a plaintiff has a claim in force, they are on the record, if you will. Even if they're not giving a deposition, everything they do, everything they say is subject to scrutiny and possible presentation before a jury in court. But the statutes provide that today, in this mediation, we will have a timeout from this lawsuit. The plaintiff will have an opportunity to go off the record. Nothing that happens here leaves the confines of this office. If we're able to settle the case, wonderful. The person has peace, they avoid uncertainty, they avoid expense, they go on with their lives. If we don't settle the case in those unlikely events, then it's as if today never happened in the first place. So we have a unique opportunity, a riskless opportunity for both sides to think carefully about the other side's position and see if we can arrive at that point of equal unhappiness.
Well, but there are some other benefits. Sometimes in a mediation, you actually get an apology from the person who blew the stop sign. I've never seen that happen in a jury trial.
Exactly right. And that's reason number two why we settle cases. Reason number one is expense. The second reason is to have peace, to put it behind you. You and I have both tried cases, and I don't know if your experience is consistent with mine, but I have never once at the end of a mediation had a client of mine, plaintiff or defendant, leap to his or her feet, grab my arm excitedly, and say, boy, that was fun, let's do it again. And so bringing peace to people is a big part of this. Even those curmudgeons who think that they're stalwart and they'll go into court and have their day, secretly feel relieved when a case is put behind them.
Well, that's certainly true. Another advantage, and you touched on it earlier, Mark, is subrogation. Most people don't understand that their first party coverages, their med pay on their car, their health coverage, their Medicare, Badger Care, Healthways, all of those people that paid some of the bills that were incurred because of your injuries in the accident are entitled to get their money back. If we go to trial and the jury awards those bills as reasonable, necessary, and as a result of the accident, all of those other carriers automatically get 100 cents on the dollar. Those carriers don't contribute anything toward the expense of litigation. But in mediation, you do something about that, don't you?
Well, we do. I'm able to make contact generally with the attorneys who represent these subrogated interests, whether it's the health insurer or the medical payments carrier, or sometimes even the federal government, which has worked out a special scheme to deal with those claims. But in any event, there can always be some room for compromise in such situations, because the health insurers, the medical payments carriers, they all recognize that there is a cost to them as well to continue to participate in the litigation. Almost always they've retained lawyers who are expecting to be paid one way or the other. They also know that if the case goes to trial, that lawyer will have to participate at the pretrial conference and then sometimes even attend the trial if there's a controversy about whether the medical bills that were incurred are related back to the injuries from the accident. So those carriers are willing, for a variety of those reasons, to get their files closed and compromise their claims. That is, take less than 100 cents on the dollar to mediation, often a reduction by as much as 25 to 33%, or even more if the circumstances warrant.
So it puts more money in the injured person's pocket.
Exactly right. For every dollar we can take away, if you will, from the subrogated interest, that's a dollar that goes into the pocket of the injured person. And that's one of the principal advantages, as we mentioned before, to settling at mediation. We can take advantage of those carriers' willingness to take a reduction. We're not taking advantage of them, we're helping them, but we're equalizing the unhappiness, as I mentioned before.
One of the things that is frustrating to many of my clients, and I'm sure most people's individual clients, is in a jury trial, it's a kind of an artificial setting. There are rules, objections. You can't talk about that because it's hearsay. And you really can't tell your story in an uninterrupted fashion. One of the benefits I find with a well-run mediation is my clients get a chance to tell their story, to tell you, to tell everyone, to tell the other side, this has really interrupted my life. I couldn't go to my grandmother's funeral. I couldn't go to the hunting camp that year. We really had a good car and no car payment. And after this wreck, we had to buy a bad car and get a car payment. It's impacted our life. It's stressed our marriage. It has caused some real difficulties. A mediation affords that opportunity of face time, not only with the other side, but with an understanding neutral. That's you, the mediator.
Well, that's right, George. You know, frankly, that's a big part of the peacemaking process. Often, plaintiffs in cases just need to be heard. And while I go to great lengths to explain to them early in the mediation process that I'm not the judge, I'm not the decision maker, I ultimately play the role with most people, at least to listen to them, to hear them out as if I were sitting on a jury, only without the black box of all these legal rules standing between their truth and their verdict, their outcome. So they get to tell me everything. And especially for those people who are in love with the idea that maybe they should have their day in court, I help them understand what it's not like to be in court. And often it's the case that 80 or 90% of what truly concerns a person about their accident, for example, the loss of the car that they love so dearly, issues like that are very important to us as people, nevertheless are irrelevant to the proof in the courtroom. And I need to make these miserable people even more miserable by helping them understand how the legal system is going to keep their truth away from the ears of the jury should they decide to try their case.
And it's not quite like it is on television, is it, Mark?
It's completely different from what we see on TV, exactly. And that's one of the downsides, frankly, of people's perceptions. So often they want the Denny Cranes of the world. You know, they want the flamboyant, outrageous conduct in court. But at least in this neck of the woods, northeast Wisconsin, the lawyers have learned the sense of decorum that the court requires. And often that sense of decorum disappoints people who were expecting Hollywood rather than Oshkosh.
Let's take our second break, and when we come back, we'll talk about the health of the legal system generally, because it is their law.
Absolutely.
We'll be right back. Welcome back to It's Your Law. I'm George Curtis, and Mark Pennow, who is one of the most popular and successful mediators in the state, is here to do some work, and he agreed to give us a half hour before he does his work as a mediator to explain a little bit about how it works, why it works. Well, one of the reasons we have it is there was a change in the law about a dozen years ago.
That's right. A statute was passed that allowed circuit judges to refer cases to what we call alternate dispute resolution. The statute provides for 8 or 9 different varieties of that alternate dispute resolution, but the lawyers almost always select mediation. It's non-binding, that is, either party can walk away, but the spirit of the statute, as well as its letter, requires that people participate in earnest, that they come and really try to pay attention to their case and make an effort to settle it if they can. The judges discovered that they have the option to invoke that statute, but judges don't get paid by the piece. That is, they don't earn their money on the basis of how many trials they take. And what with some other issues in the criminal justice system, for example, that are beginning to overwhelm our courts, the judges thought that these civil matters could often and should often be resolved in mediation. And so that's become the trend. In the year when we had those 305 jury trials that I talked about before, we had 247 circuit judges in the state. And so when we hear judges say that these days they only see 1 or 2 civil trials a year, well, that's statistically very accurate.
Oh, yes. I think I've only had 3, possibly 4 jury trials so far this year, and that's 3 more than everybody else I talk to.
That's right.
Who does this kind of work.
Yes.
It isn't that they aren't working. It isn't that they're not representing their clients. There's a different process, and there are many, many other factors afoot. You touched on a big one, cost. But the legislature has been very busy the last couple of years and really has changed the game. People are unaware of how much good or harm the legislature does to our legal system. Now, you mentioned the law that provided for alternate dispute resolution, resulting in judges saying, I'm not going to give you a trial date until you have mediated, because you can save us a lot of work. But there have been other changes in the legislature that really impact cases. For example, last week I was representing someone else, but I watched an $8–10 million case get kicked out of court because the experts for that severely injured person did not meet the Daubert standards.
Yes.
Explain that.
Well, the legislature has determined that they're going to set the bar for the standard for expert proof. That is, they're going to insist that expert witnesses' credibility be judgeable, that is decidable, by the judge before the jury even gets to hear what their opinions are, on the basis that the expert isn't expert enough or doesn't have a sufficiently sound foundation to give the testimony he's about to give. And that's huge in cases, especially cases that are testing the fringe, cases that go into areas of our world that are rarely explored. Some of these areas, there's scant true expertise because these concepts are so new and novel, and we're discovering new diseases and new problems in our world. And the expertise that the Daubert standard requires often just doesn't exist in the world. We've got to feel our way along in some of these areas, and the Daubert law can stand in the way of that.
Well, and there have been lots of other little tamperings with our civil justice system over the past few years. We have reduced the minimum that someone has to have in terms of liability insurance, in terms of med pay. We've taken away joint and several. We've taken away stacking. We've changed the definition of a phantom driver. All of those things really affect the rights of individuals, really, in my opinion, and I have the plaintiff's bias and I'll admit it, reduce the value of the individual's personal liability insurance policy without them ever being told or getting a reduction in premium, and at the same time have expanded the rights of insurance companies to avoid responsibility, limit responsibility, stacking being an example. But I probably missed a lot of things, and you may see some of them differently.
Well, George, for me, it's always been a question of predictability. The law exists in America because of a concept called stare decisis, which is a Latin phrase which basically means same is better than different when it comes to the law. And so these abrupt reversals in the legislature, these changes of direction, depending on the politics of the administration, regardless of your political stripe, cause us in the legal business to be even more uncertain than we used to be about the outcome of cases. Reason three we settle cases on top of the expense and the peace is to avoid the uncertainty that's introduced at trial. And with all of these changes in the laws of our state and in the case law coming down so rapidly, and making such profound changes, the introduction of uncertainty is about twice the factor it ever used to be, because the results are increasingly unpredictable by the lawyer whose job it is to give his client the advice that person needs to make good decisions.
Now let's throw in the economy. It's no secret over the past dozen or so years, especially since 9/11, which is the mark that I use, the economy has gone south for many people. We have more unemployment. We have more people who are in real need, more people who really don't have health insurance, more people who have let their car insurance lapse, or they've erased some parts of their car insurance. And when they have the misfortune of an accident, it really impacts their families like never before. Has there ever been a more important time for a citizen to visit his or her insurance agent and get a real awakening as to what they have and what they need?
Oh, absolutely. And that needs to be done every other year, if not every year. It used to be that when we bought car insurance, for example, we had what we had, and that would not change from year to year, from decade to decade. Nowadays, with the changes that are being made in the legislature, you have to check at least every 2 years, if not every year, with your insurance agent to make sure the coverage you have provide you with the protection not only that you need, but also that you think you have, because you may not have the insurance protection that you had 2 years ago. You have no idea it's changed, but it has, and so you have to check.
And when you get in the accident, you might find that the legislature has rewritten your coverage and you weren't told about it.
Exactly right. And if you were told about it, it was buried in a myriad of paperwork and fine print that, frankly, not even the lawyers understand. That's why we go to court so often to fight about what insurance policies mean, because sometimes the lawyers can't even tell.
Well, when people hire me, and hopefully a few of them hire me every week in accidents, I say, bring in your insurance policy. In the last 4 months, no one has ever found their insurance policy. I have to write to the insurance company and get the policy, and the clients don't recognize it. They are amazed to find that a typical car insurance policy in Wisconsin is a deck sheet showing what you paid for, followed by 28 pages taking it away paragraph at a time.
Exactly right. The details, the fine print, are often determinative in these cases, and frankly those details are indecipherable by most every non-lawyer and by many lawyers themselves.
Mark Pennow, we're out of time. Always a delight. I know you've got to get ready for a mediation, and I do too, but thanks for being on the show.
George, always a pleasure.
And thank you, ladies and gentlemen. I want to thank Mark Pennow for sharing his wisdom and experience with us. One thing we didn't get time to discuss is the effect on the legal profession of fewer jury trials. When Mark and I started out, we had the privilege of trying unlimited jury cases. It only comes from practice. The only way you develop the skill is by doing it again and again. On the other side of that coin, jurors almost unanimously, once they have had the jury experience, say, this is important. I am so happy I did it. I understand that this is not only a right, it's a privilege, and it's a duty. Our legal system is dependent upon the jury system. It's important that we do have jury trials, that we develop experienced lawyers, and we treat people to the privilege of being jurors. Then they will appreciate what a great country we have, and they will fight for it. That's my opinion. I'm George Curtis.